Stop what you are doing. Because right now, somewhere in America, a 68-year-old retiree just watched a divorce judge hand over $180,000 of her savings to a son-in-law she never even liked. She did not make a legal mistake. She followed all the rules. She paid off her house. She saved carefully for 40 years. She gave her son a generous down payment for his first home as a wedding gift because she loved him and she loved what their future looked like. And in a single court hearing, half of that gift became legally classified as a marital asset, belonging equally to the spouse in the divorce. Your adult child's divorce is one of the most common and least discussed ways a retiree's estate gets drained, and the legal system is perfectly fine with it. In today's video, we are going to expose the exact legal mechanism that turns your generosity into your liability. We are going to do the real math on a standard retirement estate. And then we are going to give you the 3 legal tools that estate attorneys use for wealthy families. Tools that most middle-class retirees have never been told about. This is not a scare video. This is a legal education video. By the end of the next 28 minutes, you will know more about protecting your legacy from a son or daughter's divorce than 95% of parents in America. 130. Here is the question we are answering today. If you give money, property, or assets to your adult child, and that child later divorces, does the spouse have a legal right to your money? The answer is, it depends. And that "it depends" is the most expensive 2-word phrase in retirement planning. Let's break it down. This channel exists because the financial system is set up to inform the wealthy and leave everyone else to figure it out on their own. If you are new here, hit subscribe, because we cover the legal and financial traps that affect working retirees, and we do it without the jargon, without the sales pitch, and without pulling any punches. Now, let's talk about your estate and your child's marriage. Segment 2, the inheritance myth. 8 minutes. Setup, build the common belief. Most parents operate on a belief that goes something like this. What I give to my child is my child's. It has nothing to do with their spouse. That belief is based on a real legal principle, and it is dangerously incomplete. Here is the real principle. In most states, an inheritance or gift received by one spouse is legally classified as that spouse's separate property. It does not automatically become marital property. The divorce court cannot simply split it 50-50. So far, so good. That sounds protective, and for many situations it is protective. But here is where the trap springs. That protection is not permanent. It is not automatic, and it can be destroyed in dozens of ways that no one warned you about. Most of them by accident, most of them out of love. The law calls it commingling, and it is the #1 way a protected inheritance becomes divorce court property. 515. Commingling means mixing a separate property asset with a marital asset. The moment that happens, the moment your gift or inheritance touches the couple's shared financial life, the separate property protection begins to erode. Let me give you 3 real examples of how this happens, and I want you to think about whether any of these applies to something you have already done. Example 1. The joint bank account. You give your daughter $40,000 as a gift after her wedding. She deposits it into the joint checking account that she shares with her husband. They use that money over time to pay bills, buy groceries, take a vacation. 2 years later, they divorce. The $40,000 is gone, not because they spent it all, but because the moment it entered that joint account, the funds became legally inseparable from marital funds. Your daughter's attorney may argue it was separate property, but the husband's attorney will argue it was commingled, and courts frequently agree. Example 2. The home renovation. Your son owns a condo before he gets married. You give him $25,000 to renovate it. He marries. The condo appreciates by $80,000 over 6 years. They divorce. Your son assumes the condo is his separate property. He owned it before the marriage. But his spouse's attorney argues that the marital community benefited from the renovation, and that a portion of the appreciation is marital property. In many states, this argument wins. Example 3. The down payment on the marital home. This is the most common one. You give your child $60,000 toward the down payment on their first home, a home they buy together after the wedding, titled jointly. The home is marital property. Your $60,000 helped create a marital asset. In a divorce, the court does not care where the down payment came from. The home, and all of its equity, is split according to the marital property laws of that state. Your $60,000 gift just became a $30,000 gift to your future ex-son-in-law or ex-daughter-in-law. Segment 3. The commingling trap. 8 to 12 4 minutes. Establish the legal framework. Let us go a level deeper, because understanding the law here is what separates parents who get protected and parents who get drained. There are two primary property systems in the United States. 9 states use what is called community property law, where essentially everything earned or acquired during a marriage is owned 50-50 by both spouses. Those states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. The other 41 states use what is called equitable distribution, where a divorce court divides marital property in a way the judge considers fair, which is not necessarily 50-50, but usually comes close. In both systems, the starting principle is that inheritances and gifts to one spouse are separate property. But in both systems, that protection can be lost through commingling, through a concept called transmutation, or through the actions of the spouse who received the gift. Transmutation is a legal term that means a separate property asset gets converted into marital property, either accidentally or intentionally. And it happens more often than you think. Transmutation example. Your child adds their spouse's name to a bank account that holds inheritance money. That single act, in many states, legally converts the asset from separate to marital property. 930. Now, there is a legal defense against commingling. It is called tracing. If your child can trace exactly where every dollar of your gift went, if there is a clear, documented, unbroken paper trail, an attorney can sometimes argue in court that the original separate property can still be identified and protected. The problem? Most families do not document gifts. There is no signed agreement. There is no promissory note. There are no separate accounts. There is just a wire transfer with the memo, "Love, Mom, and Dad." And that is legally worthless in a divorce proceeding. 10:15. Here is the part of this conversation that gets uncomfortable. When you give money to your adult child, you are also giving it to their spouse. You may love that spouse. You may trust them completely. But you cannot predict the future. You cannot predict what will happen to that marriage 5 or 10 years from now. And here is the brutal truth. The divorce rate for second marriages is over 60%. The divorce rate for couples who marry under 25 is higher still. Statistically, a significant percentage of your children who are married right now will eventually go through a divorce. This is not pessimism. This is actuarial reality. And it is why protecting your estate from a potential divorce is not a betrayal of your child or their marriage. It is responsible planning. Segment 4. The case study, 12 to 1600, around 4 minutes. Introduce the family. Make it real. I want to walk you through a composite case that represents what we see playing out across America right now. The names are changed, but the numbers are real. Meet Robert and Carol, ages 67 and 64. Robert and Carol retired in 2019. Between them, they have a home worth $480,000, paid off, and a combined $620,000 in retirement savings. They have 2 adult children. Their son Michael, age 38, married his wife Jennifer in 2018. In 2019, Robert and Carol made 4 separate financial decisions that felt completely natural at the time. Gift number 1. They gave Michael and Jennifer $80,000 toward the down payment on their first home, a house purchased jointly, titled jointly. Gift number 2. They loaned Michael $20,000, informally, no paperwork, to help cover Jennifer's medical bills from a difficult pregnancy. The money went into their joint account. Gift number 3. They gave Michael $40,000 from a CD that matured, as a Head Start gift. Michael deposited it into his personal savings account, but 6 months later, moved it to the joint account when they were short on mortgage payments. Gift number 4. They co-signed on Michael and Jennifer's $45,000 car loan to help them get a better interest rate, 13.15. In 2024, Michael and Jennifer separate. The marriage lasted 6 years. They have 1 child together. Jennifer files for divorce. Robert and Carol sit down with Michael's divorce attorney and ask the question every parent asks: how much of what we gave Michael is protected? 13.45. Gift number 1. The $80,000 down payment. The home is marital property, purchased jointly during the marriage. Under their state's equitable distribution law, the equity in that home, which has grown to $140,000, is subject to division. The fact that the parents provided the down payment is a factor a court may consider, but it is not a guarantee of protection. Robert and Carol's attorney says their best-case scenario is recovering $40,000 of the $80,000 in court. Worst case, nothing. Gift number 2. The $20,000 loan with no paperwork. Without a promissory note, without signed documentation, this is legally indistinguishable from a gift, and it went into the joint account. The attorney says, this money is gone. Gift number 3. The $40,000 CD gift. Michael moved it into the joint account. Commingled. The paper trail is broken. The attorney says the tracing argument is weak. They might recover a portion, but it will cost $8,000 to $15,000 in legal fees to fight for it. Gift number 4. The co-signed car loan. Robert and Carol are still legally obligated on that loan. If Michael stops making payments during the divorce proceedings, the lender can come after them. Total exposure for Robert and Carol on $140,000 in gifts and obligations. Potentially $90,000 to $140,000 lost or at risk, plus legal fees, plus the co-sign liability. 15:30. Robert and Carol did nothing wrong. They were generous. They were loving. They followed their instincts as parents. And those instincts, without the proper legal structures, cost them a significant portion of the estate they spent 40 years building. Now let me show you how to make sure that never happens to you. Segment 5. The true math. 1600 to 2000. Around 4 minutes. The math frame. 1600. Before we get to the legal solutions, I want to do what this channel does best. I want to do the actual math on what is at stake. Because the numbers change the conversation. The average retiree couple in America today has a net worth of approximately $1.2 million. That includes home equity, retirement accounts, savings, and other assets. About $450,000 of that is home equity. About $620,000 is in financial accounts, and about $130,000 is in other assets. Now, they have 2 adult children. Statistics say there is a meaningful probability that at least one of those children will divorce during their lifetime. Let us be conservative and say 1 divorce, and let us assume the retiree parents have been normally generous, not recklessly so. Typical exposure calculation. Direct gifts and loans to the child, down payment, car, renovations, education. Average $60,000 to $120,000 over a 10-year window. Co-signed debt obligations. Average $30,000 to $50,000. Expected inheritance the child will eventually receive. $150,000, $300,000, which, without proper trust structures, becomes a marital asset at the time of distribution. The inheritance timing bomb. 1730. That last number is the one most parents completely overlook. Let me explain. If you die and leave $200,000 to your adult child, and your child is still married when they receive that inheritance, the legal protection of separate property depends entirely on what they do with the money. If they put it in a joint account, it is marital property. If they use it to pay down the jointly owned home, it may become marital property. If the marriage later falls apart, that $200,000 you worked your entire life to pass down could be cut in half in divorce court. Now do the math. 2 adult children, standard estate, conservative estimates, a divorce for 1 child, handled with no legal protection structures in place, conservative estimate of estate exposure without protective structures, $180,000 to $320,000. For a $1.2 million estate, that is 15% to 27% of your entire lifetime of savings, handed to someone you did not choose. 1845. So the question is not whether you should protect your estate. The question is, which legal tools do you use? And how much do they actually cost? Let me give you 3, ordered from most powerful to most accessible. Segment 6. Legal defense number 1. The Irrevocable Inheritance Trust. 2000 to 2330, around the 3.5 minutes. Introduce the tool. Legal defense number 1 is the most powerful and the most used by high net worth families. It is called an Irrevocable Inheritance Trust, sometimes called an IIT, a bloodline trust, or an inheritance protection trust. Here is the core concept. Instead of leaving your estate directly to your children, which exposes it to divorce, creditors, and lawsuits, you leave it to a trust. Your child is the beneficiary of the trust, not the owner. The trust distributes money to your child, not as your child's property. Legal principle. A beneficiary's interest in a trust is generally not a marital asset. A divorce court cannot divide what a person does not legally own. You, as the parent, work with an estate planning attorney to create the trust during your lifetime. You name your child as the beneficiary. You name a trustee. This can be the child themselves as a co-trustee, or an independent trustee, or a corporate trustee. The trust document contains what attorneys call divorce protection language, specific clauses that state the trust assets are separate property, cannot be commingled with marital property, and cannot be distributed in a way that would expose them to a spouse's claims in a divorce. When you pass away, your estate, or the portion you designate, flows into this trust. Your child benefits from the assets for their entire lifetime. They can receive income. They can receive principal distributions for health, education, and support. But they never legally own the assets in a way that a divorce court can reach. A well-drafted, irrevocable inheritance trust typically costs between $3,000 and $8,000 in attorney fees to establish, depending on complexity and state. Compare that to the $180,000 to $320,000 in estate exposure we just calculated. You are paying roughly 1 to 2% of the at-risk amount to eliminate the risk entirely. That is not an expense. That is the highest returning investment in your entire retirement plan. An IIT also protects against your child's creditors, bankruptcies, and lawsuits, not just divorce. It is the most comprehensive estate protection tool available. 2230. 1 non-negotiable truth. This trust must be established before the divorce begins. Once your child's marriage is in trouble, once divorce proceedings have started, it is too late to create protective structures. Courts will view any last-minute transfers as fraudulent conveyances and void them. The time to build the shelter is before the storm, not when you are already watching the roof fly off. Segment 7. Legal defense number 2. The prenuptial agreement. 2330 to 2600. 2.5 minutes. 2330. Legal defense number 2 is the one that makes parents squirm, and I understand why. It is the prenuptial agreement. Most parents will not bring this up because they are afraid it will insult the future spouse, damage the relationship, or signal distrust. I understand that. But let me reframe it for you. A prenuptial agreement is not a prediction that the marriage will fail. It is a legal acknowledgement that both parties enter the marriage as individuals, with their own assets, their own family inheritances, and their own financial histories, and that they want to define in advance how those separate interests will be treated if the marriage ends. How it protects your estate. A well-drafted prenuptial agreement can specifically address parental gifts and inheritances. It can state that any money, property, or assets transferred from your child's parents before or during the marriage shall remain that child's separate property, regardless of how it is used or where it is held. It can also address the appreciation on those assets. A prenup can state that even if your child's inheritance grows in value during the marriage, that growth is separate property. And critically, a prenup can specify that commingling does not convert separate property to marital property, as long as proper records are maintained. A prenup that specifically names parental wealth and inheritance as protected separate property is one of the strongest legal defenses you can put in place, and it costs your child, not you. How to have this conversation. If your child is not yet married and you want to protect the estate you plan to leave them, there is a way to have this conversation that is direct, respectful, and effective. Say this: "We love you, and we love partner's name." This is not about trust or pessimism. This is about the fact that we have worked 40 years to build something, and we want to make sure that whatever we leave you remains yours, no matter what life brings. A prenup that addresses parental gifts protects you both. If anything ever goes wrong in the marriage, we don't want money to be the thing that tears you apart further. That is not an insult. That is wisdom. And if a future son or daughter-in-law refuses to agree to basic inheritance protection, that itself is important information. Segment 8. Legal Defense Number 3. The Gifting Protocol. 2600-2830. 2.5 minutes. The most accessible protection. Legal defense number 3 is the most accessible and the one you can start implementing today, regardless of whether you have a trust or a prenup. It is what I call the gifting protocol, a set of documentation habits that create a legal paper trail around every financial transfer you make to your adult children. The 4-step gifting protocol. Step 1. Write a gift letter. Every time you transfer money to your adult child, create a signed, dated letter that states, "This is a gift intended solely for child's name." It is not a gift to the marital community. It is the separate property of me and is not intended to be commingled with marital assets. Step 2. Use a separate account. Instruct your child to open a separate, individual bank account, not a joint account, and have all gifts deposited there. This is the single most important commingling prevention step you can take. Step 3. Document loans as loans. If you are giving money that you expect to be repaid, even informally, create a simple promissory note. This does 2 things. It documents your intent, and it means the gift is actually a debt on the marriage, not a marital asset. Step 4. Never co-sign. Avoid co-signing on your child's marital debt whenever possible. Co-signing makes you legally liable for a debt that is tied to a marriage you have no control over. If that marriage ends and payments stop, your credit and your assets are exposed. The paper trail is everything. 2730. Here is why these steps matter legally. In a divorce proceeding, the burden of proving that an asset is separate property often falls on the spouse who claims it. Without documentation, claims are based on memory and testimony, which courts discount heavily. With proper documentation, gift letters, separate account statements, signed loan agreements, your child's attorney has hard evidence to work with. The difference between, "I think that money was my client's separate property," and "Here is the signed gift letter, here is the dedicated account, here is the chain of title," is often the difference between winning and losing in court. Segment 9. Close and Action Plan. 2830-3000. 1.5 minutes. The summary. Fast, punchy. 2830. Here is what we covered today. Your adult child's divorce is a real and statistically significant threat to your estate. The legal mechanism is commingling, the process by which your separate gifts become marital property. The exposure for a typical retiree estate is $180,000 to $320,000, and most families have zero protection in place right now. The three legal shields are: number 1, an irrevocable inheritance trust, which structurally protects everything you plan to leave your child from divorce, creditors, and lawsuits. Number 2, a prenuptial agreement with specific inheritance protection language. And number 3, a consistent gifting protocol that creates a legal paper trail around every dollar you transfer. 2900. Here are the 3 steps I want you to take this week. Step 1. Write down every gift, loan, or financial transfer you have made to your married adult children in the past 5 years. Total it up. That number is your current unprotected exposure. Step 2. Contact an estate planning attorney, specifically one with elder law or asset protection experience, and ask about an irrevocable inheritance trust. Ask them specifically about divorce protection language. Step 3. Start the gifting protocol today. Create a gift letter template. Open the conversation with your child about a dedicated separate account for any future transfers. If you found this video useful, and I hope you did, hit subscribe and ring the bell. Every week on this channel, we expose the legal and financial traps that the financial industry does not want retirees to know about. Because the system is designed to protect people who already have attorneys and advisors. This channel is for everyone else. Free estate risk assessment. Go to the link in the description. In 60 seconds, calculate exactly how much of your estate is currently at risk, from divorce exposure, probate, Medicaid, and state taxes. Get your free personalized estate risk snapshot now. Thank you for watching. I will see you in the next one.